Hi, this is Todd Phillips, tax attorney. This is Smarter About Taxes. Today we've got a guest, Garrett Farmer with NAI Legacy. Garrett is a broker who specializes in tax solutions to real estate problems, also specializes in real estate investment. He's the managing broker for NAI Legacy. And we're starting a segment today where we deal with real live client questions. I got to do a disclaimer real quick here. I am an attorney. I'm not your attorney. An attorney-client relationship can only be done through a contract. And because of that, you can't rely on any of this advice. Okay, it's just here for you to learn from and for me to teach you. You also can't take what we teach you today and go out and sell things based on our advice. You'll see the disclaimers on your screen. Please take a moment to read it. All right, Garrett. Well, thanks for joining me. Why don't you tell us real quick about your background a little bit?
Yeah, thanks, Todd. Thanks for having me. Well, NAI Legacy, we are the Minnesota division for NAI Global. NAI Global is an international real estate professional services firm, just over 360 offices, about 7,000 brokers kind of throughout the network. Our territory is basically the state of Minnesota relative to my franchise agreement with NAI, but we specialize in sort of tax advantageous investing solutions, primarily for the private investor, private sector under 1031, Section 1031 rules, and then other kind of tax deferment options that may apply relative to the client. But we really have kind of positioned ourselves as the national tax solutions arm for all of NAI Global. So we work with our offices in California and our offices in Florida and kind of elsewhere across the country. So we're really central in the country, but we do kind of have a borderless territory when it comes to our investing solutions, and that are mostly designed for the private investors.
Full disclosure, you and I have known each other more than 20 years and have done a lot of transactions together over those years,
Correct.
All of which have resulted in some tax savings for clients. So great story. Anybody that wants to learn more, feel free to reach out to us. Well, let's dig in. What's the client question today?
Well, the client question today, again, a little context on NAI and who our primary client is, but let's just say, for example, it's a private family. There may be not to use the word legacy, but we do see a lot of legacy or generational business kind of in our client approach. But let's say it's a legacy family that has a number of commercial assets. And the question today that has been asked recently is, I am the nephew of the patriarch or the founder of the company, if you will. There has been some estate planning, but the patriarch has passed, and I am the party that is now inheriting the property. I'm not blood related, but I'm family related, but I am named in the estate as the receiving party to the real estate. The question then is, now what? What can I expect? What do I do?
Step up in basis, right?
What are my options, and what is the step up in basis I'm hearing about, and what does it mean for me?
Perfect. Let's do a quick example. Let's imagine, if you will, $1 million property. You bought it for $1 million 30 years ago. The value of the building was $800,000. The value of the land is $200,000. Over 27 and a half years, we've depreciated that. We've taken those paper losses, and the value's gone on paper from $1 million down to $200,000. All that's left is the value of that land. As a reminder, is non-depreciable. So the person who bought that property or built that property, their tax basis was that $200,000. So if they went out and sold it for, let's say, $2 million, it's worth $2 million today, they would have to pay capital gains tax and recapture tax, a combination of that on the gain, on that $1.8 million gain. But so what happened? Yeah.
So Todd, to remind the guests, so the gain is the $2 million down to the $200,000.
That's right.
Yep. Tax basis.
$1.8 million delta, right?
Yep.
And just to keep it simple, 800,000 is recapture and $1 million is capital gain. Those rates are kind of close together right now. So that's just for us accountants to geek out over. But the basic idea is you're paying some tax, right? And if you have debt on that, let's say you leveraged it up to $2 million and you took out a loan against it, what's the effect on basis? Well, it's irrelevant. Debt is irrelevant to basis. Well, I'm oversimplifying. If we have a partnership or an S corp and we got basis going on or debt going on, that creates basis. But just purely this piece of property owned outright. So let's say now the nephew gets it. We have to make a distinction here on when you get the inherited property makes a difference in whether you get the step up in basis, and who you are in relation to that party makes a difference. And I'll tell you the differential points. Number one is, If you get it during the lifetime, we call that inter vivos. They're like potato. You'll hear me say revocable or revocable all the time. They're the same terms. Okay, inter vivos means you get it during lifetime. You're going to get their basis. So if he gave it to you the day before he died or she died, you're going to get their basis. That's a bummer. You don't want that result, right? If you get it to them when they die, you're going to get a step up to the basis on the valuation date. And the valuation date is either the date of death or 6 months later you get to choose. So if we do a couple different valuations, you get to pick the higher one of the whole estate. And on big estates, it's a big deal when you do it. But anyway, so you get now this person who's your potential client probably has the $2 million tax basis and can sell this property income tax free. Well, why does the IRS do that? Great question. Because, or the tax code, I should say, the IRS does not make the laws. Congress makes the laws. Congress made the step up in basis on death because they charge a massive inheritance tax. So if this person had an estate over $3 million in the state we're in, Garrett, Minnesota, or over $12 million and change on a federal estate, they're going to pay some estate tax. If you're under that, you get the step up in basis and you don't have to pay estate tax. That's where I think most people land. That's a pretty cool deal. But when you get into the big ones, then we got to do estate planning. So when you get it matters. And even if you don't get it in that during their lifetime, but the gift was made during the lifetime. So with some of our bigger clients, we're doing both revocable trusts and irrevocable trusts. That's not the subject here today, but the point is you got to remember that term, irrevocable, and look for it. Lots of irrevocable trusts are done before death. And that property gets transferred into the trust. And if you're the beneficiary of an irrevocable trust that was created before death, and it was a certain kind of trust, you're going to get their basis. Okay. That's done in order to escape these bigger estate tax things. They're trading the fact that you're going to get whacked on your income tax is a smaller delta than what you would have been whacked on the estate tax.
Sure.
Really smart planners like me, we get in and we figure out what should go in what buckets and try to maximize all of it and play that game. Not everybody's astute at that, so watch for those terms. Okay, the other question. So then who you are as a relative, the only time it matters is if you're the spouse. Okay, so spouses can get a step up in basis. Sometimes in some states it's 50%, in some states
You're
it's 100%.
talking about the spouse of the deceased party, not the. Okay, yep.
Correct. So if you're talking about a nephew,
not a true
a
beneficiary or
a friend, anybody, a business, anybody else who's going to get the property,
correct.
all get a step up in basis. Okay,
Right.
100%.
Yep.
As long as it's done at death. So hopefully that answers that question.
Let's go back and explore the actual time of the gift or the time that you alluded to before, because I think this might be confusing for some clients. So, and maybe the lesson is for the client, the inherited party, or what would that term be? The inheritee, like the person that inherited
the heir or the
heir to this portfolio or to this estate. Should they be concerned with how this is being documented? Like, and do they have a say in the matter?
Probably don't have much of a say in the matter unless you do the will or the trust.
Sure.
But for sure, you want to make sure everything's, if you're counseling somebody who's your parents, you for sure want to get a qualified attorney in there that really knows what they're doing, and probably get both a income tax person and an estate tax person to the table and let them duke it out so that you make sure all the I's are dotted and T's are crossed. But yeah, if you mess this up, I just brought on a new client, Garrett. It's a really sad story. I won't get into the details because it's an S corporation and there's 2 of them. But basically, they did things in the wrong order, and it's going to cost them 30% of his inheritance in tax because they did stuff in the wrong order. If you would have called me a month before his dad passed away, we could have fixed all of it, but I didn't hear about it until I saw the K1. So
yeah, and I've heard of these scenarios. We seem to get those calls. It's kind of like what you and I joke about on the 1031 side. We get that day 45 panic call. I haven't found my replacement option yet. It's kind of the same thing with this estate stuff. They all of a sudden they're given this big gift, which sounds great, but there might be some things to work through. So just trying to, provide them with the best.
Call Garrett and Todd before you make a mistake. Okay, so just to recap, irrevocable trust means you probably got a lifetime inter vivos gift and you're probably not going to get a step up, but you need to investigate it. revocable trust or a will or something like that, hopefully you got the step up in basis. Estate taxes kick in. Some states like Minnesota are real low at 3 million and above, and 12 million plus or minus and above for federal. And those you're going to be responsible for as the recipient, the heir of that transfer, if the estate didn't pay it. So if you've got somebody who's not paying attention, get somebody to pay attention, because they can claw that back after you.
Sure.
Any other questions about that client, Garrett?
Yeah, let me just throw out a few questions that might come up, and this is probably outside of this particular client example, but just in general. So let's say, you and I are both in Minnesota. So let's say the primary portfolio is in Minnesota, but the heir is in another state. Where do the state-by-state rules come into play?
If we had a half an hour, we could go state by state. I think you got to pay attention for income tax purposes. What state you live in matters, and what state the property's in matters. And in some cases, you're going to get a credit for taxes paid to another state. If you live in Texas and you don't pay state income tax, and you've got a property in Minnesota, you're going to have an issue where you're going to probably pay some income tax in Minnesota and not get a credit in Texas if it's the other way around. So there's some mechanisms that can help you out, but you've got to pay attention. For estate planning purposes, it's the residency of the person that passed away is going to have the biggest impact on that state estate tax. Perfect. So you look for states that don't have estate tax, and you move there, and you take everything with you.
Exactly.
Sell your real estate and exchange to another state. Now, caveat: California is looking at following you around. So if you owned a property in California that had built-in gain, you sold it and exchanged it, they're trying to go after those folks. I don't believe that's passed as law yet, but the state-by-state issues, again, be careful, because they vary just as much as we have variance amongst people in the states.
Right, definitely something to pay attention to. All right, another question for you quickly then is, what the step up in basis, how is that calculated to a fair market value? If I want to keep the property, or if I want to, obviously selling the property would lead to some sort of market, valuation, but what's the mechanism if I want to keep the portfolio?
Any big estate of any size, you'd want to get appraisals.
Sure.
And if you're playing the valuation date game, you're going to get 2 appraisals: the date of death and the 6 months after date of death. So that's the estate. That's the settlor's job, is to take care of that stuff. If you're the person inheriting it, not your job. If you're a trustee or a settlor or an executor, I can't help you on the one short video. You're going to have to get a quick on valuation.
Sure. Yeah,
but if you keep it, you get the new basis. You can depreciate that building all over again.
Yeah, for sure. Right. So, and I do think that is the case with a lot of these, heirs and heiresses that we see to these various portfolios. There's a lot of just unpacking the questions of, okay, what did I actually inherit? Meaning it might be a commercial building, but it might be 3 tenants. It might be mixed use of some sort, and they're doctors, or they're, outside of the real estate profession. That seems to be a real big concern. And again, where NAI Legacy can come in as a solution for these families is to kind of be a professional service provider in that regard. I mean, again, our ultimate goal is, and alongside Todd's, is to sort of work with these private families and make sure that they are, growing and protecting their wealth, I guess, appropriately. And there's obviously a ton of strategies. The rules change. There's just a lot to pay attention to. But if we can at least be the real estate professional group that then leads them down a path of recapitalization or future transactions, we want to be there for them. So, and as do you. So,
as our common friend Jeff Peterson says, real estate some people may get wealthy doing real estate, some people may not, but it's the best way to protect your wealth. So if you've inherited a property and you're like, oh, I don't want to keep this thing, I want to sell it, think again. It might be the right asset to keep your family's legacy alive. Garrett, thanks for your time. We'll do this again and get some more topics going. If you are watching this, I'll put contact info below for Garrett Farmer at NAI Legacy and myself. And if you have an idea for a video or a tax question, send it to us, and maybe we'll make a new video.
Absolutely. Right. Thank you, Todd.